Good afternoon, ladies and gentlemen. Thank you for tuning in to the MKI Virtual Lecture this Friday. Today, we are looking at the role of intellectual property rights in the knowledge-based economy. It is presented to us by Dr. Janani Kwele, who is currently working as a patent examiner at Companies and Intellectual Property Commission um, CIPC. While at CIPC, he researched innovation trends and development of emerging technologies based on South African patent data. Prior to joining the IPC, he specialized in chemistry. He has worked as a postdoctoral research fellow at Petrol A, Synthetic Fuel Innovation Center. He holds a PhD in chemistry, and he is currently doing a law degree at UNISA. And thank you very much. And over to you, Dr.
Thank you very much, Mr. Lai. And I wish to thank the Moses Patane Institute for giving me this opportunity. Although the presentation for today will focus mostly on patents and patent data, or the patent as the way of protecting your intellectual property. I will touch on some of the parts that are related to other forms of intellectual property. Perhaps I should make a disclaimer first that, as Mr. Lai has mentioned, I'm actually not a fully baked lawyer. I don't have a law degree yet. My background is in science, but I know a bit of patent law. So let me go into it. And some of the views that I will demonstrate, I will put to you today are not really the views of those people who pay for my salary, and are not meant to be some kind of legal advice. So I hope everyone can see my slides. I'm on the second slide now. Basically, what is IP? What are IP rights? IP refers to the creations of the mind. You are talking about things like invention, literary works. We're talking about artistic works. You're talking about symbols and images that are used in commerce. You're talking about designs that are used in commerce. So IP refers to the creations of the mind. So how do you protect, and under which category you protect your ideas? Let me first mention this point that is always misunderstood. You don't really protect an idea, you protect a tangible form of the idea that you conceived. So for people who are into the programming, computer programs are not really under patents. They are protected under copyright. Things like books and publication and technical drawings, you protect all those under copyright. Under trademarks, you protect names of businesses, but in form of logo and unique expression of the business. The trademark really is meant to protect or identify goods and services and differentiate them from those of other companies. There is a story about Coca-Cola that they claim Coca-Cola, you can really tamper with their other properties, but really they take an exception when you tamper with their trademark. They value it so much. And then you have designs. Of course, under designs, I understand people may think that designs are not so important. If you think they are not important, designs are quite important for people who want to protect some aesthetic part of what you came up with, of what you've made, or you want to protect some functional aspect of what you've made. If you think they are not important, I invite you to go to Google and do a search for a term that is called shoe wars. This is something that happened around 2012 Olympics. Nike was fighting Puma and Adidas over the one of their running shoes. I actually came across this story when I was shopping for a running shoe. So please have a look at there. You can protect things like a mask, a design of a mask under there. Of course, I think you are noticing now under designs that you can have over one product many IP rights. I will come back to this at the end of the presentation. But for now, I want us to focus on patents. Under patents, mainly you you protect your invention. An invention, although is not defined in our law, but it's a technical solution to a problem broadly to define it. So you can protect it in the form of a product, or you can protect it in the form of a process. So when you say you protect a process, maybe you protecting a process for making a drug for coronavirus, or you're protecting a product or a composition that contains substance X and Y for use in the treatment of coronavirus. That's what you protect under patent. I understand people, when they talk about patents in South Africa, they have this temptation of associating patents with drugs and medicine. I want to emphasize this point. There are many things that can be protected under patents. It's not only medicines and drugs that are protected under patents. So now we know forms of intellectual property. Let's zoom into patents. What can be protected under patents? I already mentioned when I was talking about copyrights and trademarks and computer programs that really not everything can be protected under patents. Actually, the Patent Act excludes the subject matter that is related to discoveries, scientific methods, and literary works. You can't protect this under patents. So you won't even go to the requirements of patentability if your subject matter is this, which what it falls under the exclusions. It will just be a non-patentable subject matter. It means it does not fall under patents at all. So if it falls under patents, your invention needs to be new. It must be inventive. By inventive, it means it must not be obvious to a person skilled in the art. And then it must have some industrial applicability. There is another exclusion that is not written in a direct format, but is written in an indirect format, which is related to a method of treatment of a human body. So you can protect a method of treatment of a human body, and this is done for ethical reasons. However, in other jurisdictions like USA, which have a liberal patent law, you can protect this, but in South Africa, you cannot protect a method of treatment. I won't touch this. It's a hot potato. You can just, especially during the time of pandemic, this thing of method of treatment is a hot potato. So I won't go into details. It can need its own presentation. It's got difficult technicalities, this part. So let's go into how actually you will protect your patent. Which route you will use. There are three ways of protecting a patent in South Africa. That means patent filing. So you can file a provisional application, not a patent application. The provisional application, conceptually, it will define your invention, but you will not go into details in terms of saying, I want to protect this aspect, the scope must be this broad. You won't go that far because you are given time of a year, which is 12 months, to polish your invention, complete it, and then you file a complete application. The reason for filing a provisional normally is to set a date, enjoy some priority for a date, so that whatever you do when you polish your invention afterwards is not seen as if it's something that was already known in public before you came up, you develop your invention. So once you file a complete application, then it can proceed to grant. There is another way of protecting your patent. This route is normally used by applicants that come from other countries, that are not necessarily South Africans. So here, there is a treaty that South Africa is a party to, which is the Paris Convention. Here, someone who protected his invention initially in his country, he has 12 months to then go to another jurisdiction like South Africa to say, I want to protect an equivalent of what I protected in my country. The reason you want to do this is because by nature, the patents are territorial. So you can't have a patent in South Africa and try to enforce it in USA or try to enforce it in Botswana. So you must have a patent in that country for you to enforce it there. Then there is another way that this way is normally used by big applicants. It's under the treaty called the PCT. Under PCT, you file one application that has effect in many jurisdictions. Then after, you normally file this after 12 months of filing in your own country. Then you will file a PCT. After PCT filing, after 12 months, sometime between 12 months and 18 months, the International Bureau will publish your application. And normally this is published with a written opinion. It will cite the prior art that was used to assess your invention. They will give an opinion on whether your invention meets the patentability requirements. Then you can use this information. You have a space that is not later than 30 months to then go to each country now and try to apply for a patent in each country based on the opticity application. So this is called the national phase stage. There is always a confusion about when a patent starts to have an effect. And we used to think that this is an easy thing. Everyone understands it who's using a patent system. But we picked this up during the case of Makati versus Vodacom, that there was a lot of confusion about when actually you start to have rights, you start to enjoy patent rights. I want to emphasize here, you must have heard me talking about the provisional application. So there is no provisional patent, it's a provisional application. So up until the patent is granted, you don't really have the rights that you can enforce. The rights don't derive from an application, they derive from a patent that has been granted. So in the case of Makati, we tried to explain this because there was always this view that Mr. Makati copied his idea from the MTN patents. And there were two patents that were discussed. Actually, one of the inventors from those patents, he gave an interview. I listened to this, I think it was about an hour. He gave an interview even after the Constitutional Court has ruled on this. He said, no, he thinks Makati copied it. The idea was copied from the MTN patent. We had a look at this when we were writing this opinion piece with my colleagues, Masisange and Anat. When we look at these patents, the information that was in patent applications only became available to the public. It only became published around 2001, and for the second patent, it was in 2002. So it was agreed in the facts, if you look at the judgment, that everyone agrees that the Makati piece, please call me idea, to Vodacom around November 2000. So what we were trying to pose as the question here is that how someone can copy something that is not available in the public. So I want to emphasize again, the patents from MTN actually, they started to have an effect when they were granted in 2003. So there were no patent rights to infringe really. But again, I want to emphasize the point that I'm not trying to suggest that Makati had something that he had protected. Makati had not protected any patent. We're just giving clarity on the patent route that is available in South Africa. That's all that we're doing in this opinion piece. And we're trying to identify when patent rights accrue. Oh, well, the main point that I want to emphasize in this presentation is that there's always a perception or a misconception that people hide information in patents, that in patents somehow are blocking the flow of information, they are blocking the flow of knowledge. I hold a different view. For those who are in academia, I think you can publish and you can also patent at the same time. So these two things can work hand in hand. So the other one is not really on the way of the other one. So the reason I'm saying this is because you can file a provisional patent application. Once you have filed that, you have set the date, then you can continue and publish your work in a peer-reviewed journal. So you are not blocked, but you can't say you want to publish first and then you patent. That would be used as prior art against your invention. It would be seen as if this was already available in the field before you came up with this invention. So you must have been prompted by what was available. Then it's not new. Another point I want to make is that, as I've mentioned, patent applications, whether the patent is granted or not, they get published. This information is constantly being published, particularly by patent offices, by the International Bureau. And these come with examination reports, with reasoned opinions, citing prior art, what was used to refuse the patent, what information was used to accept the patent. So all this information researchers can use and inventors can use to form collaborations. It's the information that is available in the public that you can use. So there is no blocking of the flow of information and knowledge. In fact, there is enough knowledge for people to know what is protected, what is not protected, why it was not protected, what was cited for it to be refused. Then they can build on that knowledge and advance and give some improvements on the technology. In fact, another point is that another requirement for patentability is that you must sufficiently disclose your invention in a manner that it can be practiced by the person skilled in the art. So people who have a legal background, they tend to say in a patent we have a quid pro quo principle. It means I give you something in return for something, because patents are seen as if they are granted by the state, and in return you must disclose what you came up with. So you are not really using trade secret, so you are disclosing. So it's part of the requirement. So I want to make this point again: patents are not really blocking the flow of information and knowledge. In fact, I'm quite pleased that our universities have embraced this. I noticed that they are starting to develop some strong patent portfolios. And of course, the people who are leading this data was taken between 2007 to 2017 for that decade. So people who are leading, of course, are those universities that are known for having this strong R&D output. So you have VETS, you have UCT, you have Stellenbosch, and I noticed that UJ is coming up as well now. So really, it's pleasing to see that the universities are trying to come up with, to protect some of their inventions, and at the same time, they have not neglected the culture of publishing. So there is the publishing, and patenting works hand in hand in this case. So some universities really have been pushing the idea of commercializing some of the IP that was developed in those universities. So there are some spin-offs that came out of Cape Town. This is really pleasing. I would like to see something like this really coming from the collaborations in KZN, for the institutions that are there in KZN, working with the inventors, innovators, working together to give some spin-off as the product of that. So the two, which is high blood and Cape Catalytics, they actually came from ChemEng in UCT. And Stellenbosch is also been good. The nanofiber technologies, they actually came from the PhD research that was done in Stellenbosch. Recently, VETS developed something they call PECO from their engineering department. It's an invention that is based on a home electric grid solution. Now I want to come back to the point that I made, because I don't want to give a misrepresentation that patents are so important that we should neglect other IP rights. It's that issue that I mentioned when I was talking about the Nike shoe, where you have many IP rights over one product. This is a good example, which is coming from the Cape as well, the South African example. These guys made wine that they preserve not using sulfite. So you normally use sulfite when you preserve red wine. But in this case now, what did they use? They use rooibos and the honeybush wood chips. So this is a naturally, it's promoted. Now, this is good because it goes with the trend of going organic, vegan products and all that. So they have a patent protecting that process now, and even protecting products made by that process. So they went on, they have, of course, you can protect the logo of the business, distinguishing that we associate with this logo. If something does not have this logo, really, we didn't make it. If someone confuses this, is infringing our trademark. So it's protected under trademark. So they have wine tasting notes that enjoy copyright protection. They have description of the wine, enjoy copyright description. In fact, now in the world, it's recognized that rooibos and honeybush are geographic indications. It means whatever product you make, even if it's a lotion, if it has a word rooibos on it, somehow it must have come from South Africa. So you can't say we have something that is in rooibos extract, but it came from another country. In the world, it's recognized now, even by World Intellectual Property, that such a product must have been developed in South Africa, or must have had a rooibos from South Africa. Not anything can be called rooibos or honeybush. I won't go into details with the cell phone, but the point I'm trying to make here is that you can have many IP rights over a cell phone. The same example, the same principle I explained in the previous slide. So you can have your data processing method protected under patents. You can have your software under copyright. iPhone and Apple will be protected by trademark. Of course, the point I want to make here is that not everything really gets protected or gets disclosed. There are some trade secrets that people will keep as a know-how within the business. I accept it. But the IP forms that I was talking about today are those IP forms that are creatures of statute. The trade secret is recognized as an intellectual property rights, but is recognized under common law, really. There's no statute that is regulating that. I come back to this point I keep on making, that there is a lot of information from IP filing activity or from patent filings. In 2018, actually, it was reported that there were 3.3 million patents that were filed through the PCT route in the world. Of course, China is leading the way, followed by USA, and then your Korea Republic and the other countries they follow. If you look at the applicants in terms of the hierarchy, who files the most, it's actually Huawei. Then you go on and see, you will see you have Samsung, you have Intel. Really, the point I'm trying to make here is that people don't protect IP for the sake of protecting IP. There are tangible products that we know of, that we use. I'm sure amongst the audience here, there's someone who's using Huawei, there's someone who's using Samsung. It proves the point I'm making. But if you look at the trends on your left of the screen, you can see the world seems to be moving towards digital communication and computer technology. Most applications seem to be coming from that field. Perhaps South African inventors and people who are in R&D should keep on looking at these trends, whether we are on track with where the world is moving, whether we are moving in a different direction. It's an important way of looking at the developments that are happening in South Africa. I want to end on a lighter note with a selfie stick. I want to say there's no useless invention. We may be, even if we develop something today that we think we can't see products on the street of what was protected, that are associated with what was protected. Always remember of a selfie stick. A selfie stick was not developed for a smartphone. It was developed for a camera, and it was first patent was in 1984. Later on, people used this information, this bank of information from patents, to actually improve and make a selfie for a smartphone. I want to end on that lighter note, and I'll hand over to Ms. July, and I thank everyone for listening. Thank you very much.
Thank you very much. One of the questions that you received is, what is the difference between IP and patent?
What is the difference between IP and patents?
Yes.
IP is a broader umbrella. It's a form. So you have a form and then you have specific forms. So in a broader umbrella of IP, you have patents, copyright, and trademarks. So patents are a form or a type of intellectual property rights.
Okay.
So you have intellectual property and then you have a form of intellectual property.
Thank you very much. You talk a lot on the emerging trends on technology and its protection, especially coming from China. A lot of South African innovators have come through with Uber-like sort of ideas. Can we still look at protecting those, even though the base of the idea has already been put there?
Under South African patent law, particularly, most of those technologies will not form the patentable subject matter, especially if it's a computer program or it's a software. Those enjoy copyright protection. And for copyright protection, you don't really need to register copyright. When you make it a tangible expression of your idea, reduce it to something tangible, you have to meet, of course, the requirements of a copyright. If you go to court and someone says you infringe my copyright, so it must be original, and then you must have reduce it into a tangible form. So the point I'm making is that I've heard this question before. Really, I do not think most of those inventions constitute patentable subject matter. If they are different from what Uber came up with, I think they enjoy copyright protection, not patent right protection. Of course, there could be business names associated with that, which will not be Uber, but they will have their own logo, maybe say Taxify. So if they have their own logo that distinguishes Taxify from Uber, of course, it's their trademark if they protect it.
Thank you very much. Another question from Anonymous is, what are the best South African products or inventions that are internationally used?
I think actually some of the products that come from South Africa that you see even outside South Africa is the wine that come from the Cape. There's a lot that is coming from the Cape. I know people from the Cape even make gin from some plant varieties. So they are not really things that came from patents. Some of the products there, but some of the processing that is happening in the plant biotechnology down in the Cape are protected through patents, and they are exported to the world. There aren't so many I can think of, but if you were to look at tech per se or R&D output, I think if you are overseas, everyone who's in the R&D, particularly things like engineering, will ask you about Sasol. Sasol, now that it's extending to USA, we seem to be having that symbol, and Sasol also has strong IP protection in South Africa and in USA, where they compete. So when you go to other countries, people will ask you about the Fisher Tropsch that is being used at Sasol as a technology behind what they're making to generate fuels. So there's a second one I can think of. There aren't many, but it also really it speaks to the economy we are. We are not a big economy, I think.
Thank you very much. Another one from Anonymous. Legal, how possible it is to patent my grandmother's medical potion?
Medical?
Potion.
I kind of
How do you protect Umutkagogo here?
I kind of expected this, and actually, I'm fascinated by this because I come from a family that has a traditional healer. So you can, I know in the lab, people extract from the herbs and purify them and then package them somehow to sell them as a purified product. I think what should be happening is that those who know how extractions or an extraction of ingredients is done from the herbs need to form a collaboration with traditional healers and with those old people who know that you can just go take that plant and you boil it, give to someone to drink, and then they'll be good, like Umhlonyan. So they need to collaborate because you can't really protect a discovery, but you must show what did you do when you discovered something. So maybe you extracted, you added something, and then you made a composition. Of course, that you can patent a composition that is made from a natural product. You can protect it, but you can't protect a natural product as it is. That I found this, it works. You can't. Actually, there's a famous case around this. I think CSIR was involved. I think they were involved to use some knowledge that was derived from the Khoisan people. I think if you Google Hoodia, I think it's related to suppressing appetite. So CSIR they did some extraction and they did some lab synthesis of the active ingredients. So actually, even if we talk to WIPO, that's one of the patents that are also famous in the world. That Hoodia based patent.
Thank you very much. And I think the response to Anonymous, therefore, is to go in and do your research as see how do you get that potion out there and to the market and commercializing it. And thank you very much for everybody who has tuned in. Please note that this recording will be sent through to our YouTube channel, which is Moses Kotane Institute. And check our website, www.kotane.com, where the slides will be published in the next 24 hours. Thank you very much.
Thank you, Mr. Lai. Thanks to everyone.